Well, hello everyone. How y'all doing? It is warm in North Carolina. It's getting into the 70s now, but it is still winter, as evidenced by all the static I still have in my hair. Yes, things have been light these past few weeks because I've had a lot of stuff going on personally. Well, the big snowstorm we had delayed a lot of things, including I had to buy a new, well, used, but new to me, car to replace my old one. So I now have a 2020 Tesla Model 3 and it's really good and I love it, but it took way too long to do. It should not take that long or be that difficult to buy a used car, which sounds like the start of a commercial, but it's not because I don't have sponsors. So we're going to get right into this. And this is the Amended Complaint and Free Speech Coalition, the SCOTUS, and this is the Tennessee age verification law. The Texas one got a lot of attention. That was Paxton. That was the one that went up to the Supreme Court. And so that's going to be playing a role here. But make no mistake, the Supreme Court did not say that all the age verification stuff was A-OK. What they said was that in very limited ways, the age verification only had to pass intermediate scrutiny instead of strict scrutiny, even though it's a clear First Amendment violation because it's content-based. So that was a terrible decision. But it was limited, and that's part of what they've done here in this amended complaint. So we'll be talking about Paxton a bit, and we'll also be talking about age verification and why they're so terrible. As we've just seen, I covered the Discord breach where 70,000 users had their government IDs they're out there now. The hackers have them. You can buy them on the dark web. It's a security nightmare. It's a privacy nightmare. And really what this is a backdoor way of trying to ban porn. Let's just say what it is. They say protecting the children. They don't want you accessing porn. That's what it's all about. This is totally an attack on the First Amendment. So shout out to the Free Speech Coalition, Deep Connection, JFF Publications, Melrose Michaels, and all the other people involved in this lawsuit, and all the others across the country for trying to push forward and put an end to these terrible things. So we're in Tennessee here, and this is the Protect Tennessee Minors Act, or PTMA, and they say that it subjects to any liability any individual or commercial entity that publishes or distributes in this state a website that contains a substantial portion of content harmful to minors without first verifying the age of each user via a reasonable age verification model. Okay, first problem, there's no such thing. There are no reasonable age verification models. All of them are completely unreasonable. So they say the PTMA violates the First Amendment as it imposes a content-based burden on protected speech that must survive strict scrutiny or at best intermediate scrutiny. Yeah, they had to put that in because of SCOTUS. Yet the poor tailoring is ill-suited to the task of protecting minors from materials they may easily obtain from other sources and via other means. As we'll talk about, it doesn't even work. The PTMA also violates the 14th Amendment as a criminal law that fails to provide a person of ordinary intelligence with fair notice of to whom the PTMA applies, what is required, and what is prohibited. The PTMA is impermissibly vague, violating the procedural component of the Due Process Clause. Finally, by treating website operators as the publishers of material hosted on their websites, but produced by other content providers, the PTMA stands in direct conflict with Section 230 and is therefore preempted by that supreme federal law. So we'll get into why, and they spend a bunch of pages going over the jurisdiction and who the parties are, and the statutory and procedural history, how we got up to this point. And so Tennessee amended the law by keeping in everything except with respect to what constitutes material harmful to minors. Now it's defined as that quality of any description or representation in whatever form of nudity, sexual excitement, sexual conduct, excess violence, or sadomasochistic abuse when the matter or performance would be found by the average person applying contemporary community standards to appeal predominantly to the prurient, shameful, or morbid interests of minors, is patently offensive to prevailing standards in the adult community as a whole with respect to what is suitable for minors, and taken as a whole, lacks serious literary, artistic, political, or scientific values for minors. Now, the excess violence part, defined as the depiction of acts of violence in such a graphic or bloody manner as to exceed common limits of custom and candor, or in such a manner that it is apparent that the predominant appeal of the material is portrayal of violence for violence's sake, has been voided for vagueness and excised from the statute by the Tennessee Supreme Court. It cannot supply a basis for civil or criminal actions under the PTMA. So the excess violence part is out of there. Now, getting into Paxton, the core holding is narrowly aimed at resolving that question only, establishing the standard of review and First Amendment challenges to laws like Texas's that both, 1, adhere to the Miller-Ginsburg Obscenity Standard, and don't even get me started on that, I've got a few videos on that, I won't reiterate, and 2, produce only an incidental, not intentional burden on adults' rights. And here they quote from Paxton, "Adults have the right to access speech that is obscene only to minors, and submitting to age verification is a burden on the exercise of that right. But adults have no First Amendment right to avoid age verification, and Texas law can readily be understood as an effort to restrict minors' access. Any burden experienced by adults is therefore only incidental to the state's regulation of activity that is not protected by the First Amendment. That fact makes intermediate scrutiny the appropriate standard under our precedents." And if you want to know why they were wrong about that, and you want to see the slippery slope, all we have to do is keep reading the document. So that's exactly what we'll do. Plaintiffs here include online purveyors of non-pornographic content, some percentage of which will nevertheless fit Tennessee's definition of harmful to minors. Plaintiffs thus bring both facial and as-applied challenges requiring an analysis that the Supreme Court did not have occasion to conduct in Paxton. And as we've seen, although they try to avoid it here, we've seen plenty of other places try to extend it to social media. We've talked about Discord. More recently, there was that fake controversy on X because minors would see porn and minors would even have, the dirty pictures of themselves around because Grok, if you asked it, would take a picture of a woman and put her in a bikini. And that is exactly the same, apparently, as porn. I have no idea what's wrong with people's brains. But that's the slippery slope. It's not a fallacy. And we'll see that as we go. The Obscenity Standard, if not easy to apply, was at least easy enough to recite. The basic guidelines for the trier of the fact must be whether the average person applying contemporary community standards would find that the work, taken as a whole, appears to the prurient interest, whether the work depicts or describes in a patently offensive way sexual conduct specifically defined by the applicable state law, and whether the work, taken as a whole, lacks serious literary, artistic, political, or scientific value. Per Paxton, as long as the legislature adheres to it in crafting age verification laws affecting providers of harmful to minors contents, the resulting statute will receive only intermediate scrutiny on review. Tennessee's failure to specifically define the prescribed contents renders the PTMA as amended constitutionally suspect. This is, in fact, a fundamental feature of due process and one that the Supreme Court reiterated in Paxton. Tennessee has failed to meet the long-venerated standard by declining to outline the specific contents that run afoul of the amended PTMA. Because that statute hinders adults' exercise of protected speech without meeting the modified for minors obscenity standard in this critical aspect, it must be subject to strict, not intermediate scrutiny for this reason. And it can't survive that. Under strict scrutiny, the PTMA would be constitutional only if Tennessee could show that it serves a compelling government interest, is narrowly tailored to achieve it, and is the least restrictive means of advancing it. The PTMA largely fails to accomplish its goal of protecting Tennessee's minors. because it requires age verification in order to access only those websites that offer content harmful to minors as a substantial portion of their total content, defined as 1/3 or more. Minors will face no impediment to obtaining such material from websites watered down, either incidentally or purposefully, in order to avoid the consequences of the acts, with other content unoffensive to the sensibilities of the Tennessee legislature. I love that phrasing, because that's really what it's all about. It's not offensive to minors or to the community or harmful or anything like that. It gets their little panties in a bunch. Oh, there's nudie pictures out there. We can't handle it because we're stuck in the frickin' dark ages because of our Bronze Age religion. That's another aspect of this that never gets talked about, because this violates the Establishment Clause as well, because all of this is based in religion. All of it. You can't get there any other way. You can't get to porn bad any other way than religion. Now, we talked about social media before. Tennessee appears to have exempted social media companies and search engines from the reach of its age verification law. Ironically, however, it is those same sites that are most likely to provide a minor's first exposures to sexually explicit content. Minors also have other routes to obtaining content harmful to minors over the internet, including by pursuing such content published by persons and entities in other countries beyond the jurisdictions of Tennessee's state or federal courts, resorting to the dark web via a Tor browser to obtain material far more harmful than what's available from popular adult websites, and, of course, using a VPN. This is not gonna stop them. You're not doing anything. You're not helping. And there are alternative means available for Tennessee parents to address the Act's goal. The two major personal computer operating systems, Microsoft and Apple, include parental control features straight out of the box. Almost all browsers, including Chrome, Firefox, Edge, and Safari, also have parental control options. Parents can also use screening software that blocks messages containing certain words, as well as tracking and monitoring software. A parent may also restrict and observe a child's use of the internet merely by placing a computer in a public space within the home. All of these methods constitute less restrictive means for accomplishing the same ends. Yeah, but that would require that parents actually do something, and that's hard. No, government, please do our job for us. Now, absent from the law at issue in Paxton, the PTMA requires affected websites to re-verify their users every 60 minutes over the course of a single session, a requirement that can only exist for the purpose of shaming the adult viewer and heightening concerns about breaches to their privacy. Every hour it's got to pop up and you got to do it again. The result is as cumbersome and disquieting for the viewer as it is expensive for the company, as commercial age verification providers typically charge per verification. The PTMA also requires the age verifier to retain at least 7 years of historical anonymized age verification, further exacerbating the privacy risks to viewers and raising the costs on providers. Yeah, you know what they've been saying? Oh no, well, you don't have to worry. We'll just delete it afterwards. We'll just remove it all. It's just there for a moment. Don't start fear-mongering. Don't start being a conspiracy theorist. Don't start doing all this stuff. We'll delete it. We'll delete it. No, you won't! You can't! You won't be allowed to! For 7 years! This is what happens. And this is before this stuff even really gets going. And they're already starting to go this far. That's what they always say about the camel's nose in the tent. And that reflects the state's forbidden motive, not just to protect minors from harmful content online, but to stifle adult access to sexual content as well, which is what all this is really about, make no mistake. That was always just kind of the first step. Again, the camel's nose in the tent. We're starting to see some of the rest of the camel here. And if we don't stop it, the camel's going to be all up in your business. more so than it is already. And here's another thing that wasn't even speculated about in Paxton. This is criminal. The Texas law at issue in Paxton did not include any criminal provision, much less one subjecting a violator to 15 years imprisonment. Murderers get 12. The Supreme Court has repeatedly emphasized that statutes regulating expressive conduct must be scrutinized with special care when they are enforced by criminal sanctions. Yeah, so maybe one day the Supreme Court will learn that slippery slope is not a fallacy. Oh no, it'll just be limited to this. No, it won't. And it doesn't take long. You see, it's happening here already. If they don't stop this here, this will be the law in Tennessee. The PTMA further restricts and chills the speech of online content providers and restricts the ability of certain material to those entitled and wishing to receive it. The PTMA is riddled with vague words, phrases, and requirements. The phrase taken as a whole in the definition of harmful to minors is vague because what constitutes the whole is unclear in the context of the internet generally or a particular website more specifically. Is it just pages? Is it the entire website? Do you include links? And then substantial portion, defined as 1/3 or more of the total amount of data available on the website, is vague insofar as it fails to explain how total material is calculated and what metric is used to measure. Gigabytes? Character count? Number of images? Video runtime? May a website avoid the problem altogether by providing a link to all the anodyne content in the local public library. Yeah, you just linked all that. Say, hey, look, there's most of our content. If not, then is it by gigabyte? Okay, then we'll just use modern, HEVC on all our pornographic content, so it's nice and crunched down into just a few gigabytes while still being high quality. And we'll use, MPEG 1 on the stuff that isn't, or ProRes or something like that. And then those are really, really, really lots of gigabytes. See, there are lots of gigabytes. Or video runtime, that just means you're going to just add a whole lot of crap into the runtime of the non-offensive videos. You can do that really easy with AI these days. Yep, hours and hours and hours of an AI waxing on about this and that nobody cares about. But look, that makes it more than 2/3 of the website. The terms commercial, entity, and website lack the requisite precision demanded by the First Amendment. A commercial entity is every legally recognized entity, from the largest corporation down to the smallest sole proprietorship. The PTMA, intentionally or otherwise, requires individual performers to implement their own age verification protocols, even when relying on another company's platform to host their content. At best, this is an inefficient and cost-prohibitive way of affecting the state's interest. At worst, it is impossible where performers do not control the computer code upon which the platforms are built. It's just like when YouTube started making us responsible for SEPA. It's like, what are you talking about? We don't get any information from minors who are watching our videos on YouTube. We don't collect any of that. YouTube does. Yet we're responsible somehow? In its simplest form, a website can mean a series of connected pages under a single domain name. Often, however, web pages have more complicated structures, sometimes involving multiple domain names or subdomains, links to separate but related businesses, or links to third-party content living on different servers. In failing to define website, the PTMA likely captures far more speech than intended, and certainly more than is constitutional. Nah, it's probably what's intended. They want to stop it all. Contemporary community standards is vague and overbroad due to the borderless nature of the internet. Tennessee is a diverse state, and the contemporary community standards vary widely from Nashville to Cleveland. Yeah, it's one thing when you were talking about showing something in a theater that was at one location. This is being broadcast worldwide. Then there's another thing I haven't seen anyone else talk about, and it's really important, and that's the fact that not all minors are the same. A 16 or 17-year-old is very different than a 10 or 12-year-old. The Tennessee legislature has painted all minors, regardless of age or maturity, with a single brush, but there is a broad range of material that has serious value for at least some 16 and 17-year-olds, which might legitimately be considered harmful to a 10-year-old. And we don't question that, do we? That's what the R rating is, meaning no one under 16 without accompanied by a parent or guardian. But if you're 16, you can see it even though you're a minor. So it's fine for a 16-year-old to see it, but not a 12-year-old unless they're accompanied. Very, very different. The PTMA fails to explicitly exclude material appropriate for older minors from the harmful to minors for which access is conditioned upon proof of majority. Requiring entities that publish such material on the internet to place it behind an age verification wall infringes upon the constitutional rights of both the older minors who are denied access to constitutionally protected material and the entities who wish to communicate with them. So from that, they list all the causes of action. The first one is violating free speech under the First and 14th Amendments. The second is due process rights under the 14th Amendment. And the third is violation of Section 230. And then all the religious stuff. We pray to you, wherefore, thence respectively, and none for wherefore too. Permanently enjoin the Attorney General, his officers, agents, servants, employees, and attorneys, and those persons active in concert or participation with them. Declare that the PTMA violates the First and 14th Amendments to and the Supremacy Clause of the U.S. Constitution and is therefore unenforceable and void. Award attorneys' costs and other fees and other and further relief, etc., etc., the standard language there. So that's their amended complaint. 2 days later, the state moved to dismiss based on failure to state a claim. And we don't have that document. This document I'm reading is number 70 in the docket. 71 is the actual motion to dismiss for failure to state a claim. 72 is the memorandum in support, which is the part we want to see. So far, it's not up. But they're claiming they failed to state a claim. But it looks to me like they stated claims. They stated a bunch of claims. They stated lots of claims. There are lots of claims that were stated here. And I think they're good ones. And hopefully the courts will agree. And hopefully we'll finally get some progress on this. Because this has been crazy, this has been insane, and it's been a horrible invasion of your privacy and putting you at horrible risks of the worst kind of cybersecurity attack you can suffer, which is identity theft. That is exactly what's at stake here. All because of these moralizing busybodies who are stuck in the dark ages. So hopefully the courts will see it that way. Hopefully you've got some more ammo now. When people start pushing back at you on social media, oh, you just hate the kids. Why do you want there to be harm to minors? You've got all sorts of new arguments here, thanks to the Free Speech Coalition and the rest. Shout out to all of them. And I'll keep you updated, of course. So please, comments for the comment god, shares for the share throne. Please hit like, subscribe, and the bell. And of course, donate.bogosity.tv to keep me doing this. Not only with PayPal and Venmo, but Cash App is also up as well for those of you who wanted it. And of course, all the cryptocurrency options. I got a bunch of different cryptos you can give to me. I'll take it. And then, of course, there's being a regular supporter at Patreon, Subscribestar, or Discord. Please check those out. Thank you so very much for watching. Until next time, stay strong and be free.